The Delhi High Court will be hearing the ongoing case on petitions challenging the legal exception that protects men from criminal prosecution in cases of forced non-consensual intercourse with their wives. Now, the Delhi High Court is currently in the process of hearing final arguments in a series of PILs challenging the marital rape exception clause, Section 375 of the Indian Penal Code. Section 375 of IPC defines various acts that, if done against a woman's consent by force, fraud or coercion, or to a woman incapable of giving consent, are defined as rape. The heart of the debate is the exception 2 to Section 375, which states that any sexual act performed by a man on his own wife is not rape as long as the wife is not a minor. Well, to talk more about this, we're joined by Satyapal Jain, the Additional Solicitor General. And sir, can you explain why this should not be struck down?
See, this issue came to limelight or became an issue of debate after the very, very unfortunate and heinous crime committed on Nirbhaya. The then government constituted a committee also headed by Justice Verma, the retired judge of the Supreme Court. And they, after examining all issues in detail, also recommended the deletion of this clause exception, which says that if you commit a rape on your own wife, unless she is less than 15 years of age, which legally is not permissible.
Right, so now the government in its affidavit says that it needs more time to present its stand on the ground, that the matter needed wider consultations and a larger hearing of all stakeholders. This apart from the obvious issues of social disharmony and damage to marriage and family systems. Why?
Any amendment in law, any step that you take which involves the social relationship and involve almost each and every family, I am in total agreement with the government on that point, should be done after thorough deliberation and after thorough consultation. Because even in the committee reports also, somewhere it has been discussed. There is another point of view which says it can disturb the social harmony within the family. It can disturb the relationship between the husband and wife also. But then at the same time, all the laws, domestic violence, the 398 and all other laws, there is an apprehension of the relationship getting disturbed, social relationship, the working relationship within the family. That should not stop the enactment of the law. But I totally agree with the government on this point that this should be done after thorough consultation, after thorough deliberation, and there is no point in delaying it. Today, the time has come, technology has gone to that advancement that sitting in one place, you can consult the entire country through your computer, through your WhatsApp, through your Zoom, webs, and all those things. So this can be done, and Parliament session is there. MPs can meet formally also, informally also. Then there are standing committees which consist of representatives from almost all the political parties. They can examine it. But I think time has come when we should expedite the process and do it, though of course after consulting all the stakeholders.
Right. So as you pointed out, consult stakeholders, but just move on it. And it's possible with technology. Now, as this petition is heard in the court, there have been arguments made from certain, men's rights organizations that have opposed this petition. And many claim that Section 375 will be misused by women to file false rape cases against them if the exception is removed. So how do we ensure that it isn't?
For that, I think there have to be two factors which will have to be kept in mind. Number one should believe his wife. Why should you presume that your wife will go against you willingly, knowingly, intentionally? Why? That shows that there is some lack of understanding between the two. And if there is a lack of understanding between the two, only then there is an apprehension that wife may misuse this clause. Otherwise, if the relationship is good, I don't think any Indian wife will go to the court of law. Secondly, simply because the law can be misused, there is an apprehension that it can be misused, is no ground to withhold the law.
Correct.
Tell me one law in India, criminal law, which has not been misused. There are many cases. As a lawyer, I can tell you, after 10 years, 15 years, the man is acquitted of murder. After 8 years, 10 years, 12 years, the person is acquitted of rape and all that. There have been many examples where the law has been misused. No doubt about it. But then, such cases are not as high as would stop the passing of the act. All these apprehensions are always there, even under the Dowry Act, under many other laws. There are examples where it has been used. Even courts have been saying that. But here there is an apprehension. I think that should not be a ground to withhold the passing of the act and deletion of this clause. But as I said earlier, you also said it, and some people are of the view, if you do it after thorough deliberations, of taking all men organization, women organization, and all those who stand for equality, them also into consideration, I think the chances will be minimized.
All right, Satyapal Jain, thank you so much for speaking to us on this very, very important and sensitive topic.